Welcome to this Regulate main lecture, Intellectual Property in the Context of Robotics and AI. I'm Dr. Luke McDonough from LSE. By now, you will have seen the introductory session. In this more detailed session, we will look at each of the intellectual property rights as they apply in the context of robotics and AI, and we will study some case law. The case law will indicate the practical ways in which intellectual property can be used by people like you or your collaborators to give a certain amount of protection to the creativity, the intellectual products that you're producing. So moving on and recapping what we did in the last session, you will remember that we mentioned that the robotics and AI fields are dynamic, resource-intensive, and collaborative. And as such, intellectual property agreements between you and your collaborators will inevitably be important. You will remember that IP is not one thing. We have looked at 5 different categories of IP: patents, trade secrets, copyright, trademarks, and registered designs. Now we're going to look at them in a bit more detail. Starting once again with patents, I want to flag up a very important factor. When you have come up with your invention, it is crucial that you do not publish your invention until you file for the patent. And for many of those of us who work in universities or in the public sector, this goes against our usual practice. Usually when we create something new, we want to share it with the world. We want people to read about it. The problem is that if you publish before you file the patent, when the patent examiner looks for prior art, they will find your publication, and that publication will defeat the novelty of your application. So it's very important that you keep your invention secret and do not publish it until you file the application with your patent attorney. Your patent attorney or your technology transfer office can advise you on this. Once you file the application, you are free to publish as much as you like. So this is not a question of never publishing. It's simply a question of priority. Make sure that the priority date on your application is known to you so that you can plan your publication to follow that date. If you're submitting your work to a journal, you can also request that the journal keep the information secret. In so doing, you will already see how there's overlap here between trade secrecy and patents. At least temporarily, you're relying on others, like your patent attorney, like journal peer reviewers, to keep your invention secret. And that brings me to a very important part of the relationship between patents and trade secrets. As you can see from the diagram in the next slide, when you apply for a patent, you give all of the detail of your invention. Here we can see the robot figure, the humanoid robot figure, in a lot of detail. When you file for a patent, you have to describe how it works, and you have to demonstrate through diagrams and drawings how exactly that process works. Only if you've truly disclosed the invention will the patent be granted. This is very different, of course, from the trade secret fields. And so patents in our next slide, as you'll see, can be used as a way to publicize what your company is doing. Your competitors will read the patents that you put out. They will know what you're working on. This is part of the public function of the patent system. You can learn from what others are filing, and that becomes part of the body of knowledge. However, when the patent is granted, it gives you the right to stop any of those people from using your invention even in their own follow-on innovation. That is, until the patent runs out 20 years later. We'll move on now to the next slide and look at some case law. You may be aware of the company iRobot and its famous product, the Roomba. This is a smart device, a vacuum, that has a lot of sensors and internal electronics that enable it to maneuver itself around your house without it bumping into furniture. As you can see from the slide, a rival company tried to bring out a product modeled very much on the Roomba that looked very like it, but more importantly, from the point of view of patent law, the inner workings of the device, the inventive aspects to do with the sensors, were copied. And so this was a clear indication of patent infringement. iRobot sued in Germany. They very likely would have won the case, but Solak, the other company, settled and withdrew the product from the market. We see another case in the next slide, InTouch against Vigo. Here again we have smart products, elements of AI interacting with robotics. This is a robotic device that can move into rooms where there are patients with infectious diseases, and it can communicate with them and help to treat them. Coming out of the COVID-19 pandemic, this is the sort of device that will prove useful over the past 3 years. So what we had here were two devices that performed the same function, but looked different. And in the end, the court decided that the inner workings of the two devices were sufficiently dissimilar that there was no patent infringement here. So even though the InTouch patents were valid, they were not infringed in this case. So that's a lesson for all of us. Just because we have a patent and the courts uphold that patent, it doesn't mean that our competitors will necessarily be infringing. Sometimes it is possible to invent around somebody else's patent and get away with it. I want to talk for a moment about the Amazon one-click patent, because this is a famous software patent, which I mentioned in the introduction. These are hard to obtain, particularly in Europe, but they're theoretically possible. This is a great example of a valuable patent that Amazon held from 1999 in the United States. For those of you who've used Amazon over the last 20 years, you'll be aware that once you've put in your card details into Amazon, you could then, with one click, purchase something without having to input all of the data again, and your data would be held securely by Amazon. So this one-click patent was accepted by the US Patent and Trademark Office in 1999 as novel, inventive, and capable of industrial application. As we mentioned in the introduction, usually patents apply to hardware. This was an example of a software patent. Interestingly, however, the European Patent Office refused the application, considering that it was not truly inventive, failing the inventive step requirement, and refusing to grant it. The patent is now expired, because patents last only 20 years. But another lesson from this is that even if you get a patent in one jurisdiction, it may not necessarily be valid in all jurisdictions. Finally, on the subject of AI, a talking point at the moment is the question of whether AI can be an inventor itself. There are examples around the world of people who have used AI to help them invent new products. That might be a new chemical formulae for a medicine or something of the like. And so algorithmic creativity, generative AI, is helping humans, at some points, even making creative decisions about what the invention will result in. However, most courts and most patent offices, including the European Patent Office, have rejected the idea that you should be able to name the artificial intelligence, the software, the algorithm, on the patent application. The European Patent Office has held that only human inventors can be named on the patent application. But this is the sort of question that will run and run for the next few years. Moving on from patents, we'll return to the subject now of trade secrets. You remember that these are unregistered rights. You don't have to apply for a trade secret. And the benefit, of course, is that the protection is potentially perpetual. These are useful only where the product cannot be easily reverse engineered. Let me explain what I mean by that. If you, to use a simple example, bake a cake and you keep the recipe secret and nobody else is able to replicate that exact cake, then you have a very valuable trade secret. However, if you bake a cake and other people find it very easy to figure out how you made the cake, how much flour, eggs, water, and sugar you put in, and so on, and they're able to replicate pretty much the exact taste, then actually what you're holding as a secret is not that valuable. In fact, you have used the wrong type of IP in that circumstance. And so if you have created a mechanical invention to do with a robot, or if you have created something like a simple molecule medicine drug, these are the sorts of things that someone will be able to pull apart, study, and figure out how to make. And so just because you keep it secret doesn't mean others will be prevented from actually making what you've done. So for something that is easy to reverse engineer, like a simple medicine, a patent is a much better way to protect your product. Because even if somebody else is able to replicate your patented drug or your patented piece of hardware, you still have the 20 years of exclusive protection. However, for something like the Google algorithm for its search engine, or the recipe for Coca-Cola, where there's a level of complexity that has made it impossible for others to replicate, trade secrets might actually be the best way to protect that type of technology. The reason is that as long as you can keep it secret, and Google has been able to keep its algorithm secret for more than 25 years, Coca-Cola has technically kept its recipe secret for more than 100 years. And as long as you keep it secret, you keep the protection. So the value there is kept within the company for a long, long time. However, as I mentioned, the drawback is that if anybody can replicate and reverse engineer your invention, then it's no longer secret. It's as simple as that. So for technologies that can be easily replicated, I would not advise you to use trade secrets. I'd advise you to use patents. But the strengths of trade secrets are very, very obvious. It's a valuable form of protection that is potentially perpetual and can last for as long as you need it to. There are few upfront costs in the sense that there's no filing fee, and it's only the cost of paying your employment team at your workplace, at getting the contract drawn up with the term in it that makes sure that you keep the trade secrets. But there are also, moving to the next slide, very strong weaknesses to the trade secret protection. First, employee mobility means that your staff may leave the company, and they are permitted to take a certain amount of their own skills and know-how with them. So if you lose an employee who's utterly integral to your industrial process, they can take some of that knowledge with them and go to a rival company. But there are limits to that, as we'll see. They cannot take client lists or detailed instructions that have been marked as secret. There's a whole range of things they cannot take, but there's no doubt that when a skilled employee leaves, they do take a certain amount of knowledge with them. The use of non-disclosure agreements is usually required in the context of trade secrets. And when you're using non-disclosure agreements, it's crucial that the other person agrees and signs those agreements. And this can be tricky if you're dealing with an investor. If you're dealing with an investor who you're asking for, let's say, €500,000 to invest in the company, they may say, well, I want to see what you have developed. I want to see how it works. And if you say to them, well, we'll let you see it, but you have to sign an NDA, the investor might say, I never sign NDAs. They might refuse. And you're then in a tricky position. Because if you reveal the information without them having signed an NDA, then they may take it elsewhere. So there are uncertainties that come with this process of trying to protect a trade secret. And of course, there's also the point at which the value of the trade secret may be difficult to quantify. A patent may be easier to financialize. Investors tend to like patents because they see them as secure assets. They're registered at the patent office, and you can see the boundary of where the protection lies. With trade secrets, companies may see these as insecure assets. Investors may be less willing to invest if they see that you only have trade secrets protection. And that's why a lot of companies pursue a multi-pronged IP approach. They will apply for patents, but they will also use trade secrets for other elements of their IP. And that way, they will show investors they're serious about developing a business strategy that covers all of these elements of IP. So there are reasons to use trade secrets rather than patents, namely the low cost, the perpetual protection, but there's also reasons to not use trade secrets, particularly for things that are easily reverse engineered. And there's also reasons to use trade secrets rather than copyright, again for the lengthy period and the fact that you don't have to prove originality in the context of a trade secret. So a confidential idea will be enough. It doesn't have to be particularly original, but it does have to be detailed in some form. It usually has to be marked as secret. As I mentioned in the session, there is a legal regime called breach of confidence in the UK that is used for protecting trade secrets. The way that this works is that, as in line with the EU test, you have to take reasonable steps to keep the protection, going. In the UK context, what this means is that the information that you are seeking to protect must have the quality of confidence. It must have an obligation of confidence on the other party, and it must be used in an unauthorized way to your detriment. And so we can go through the different categories: the quality of confidence, the obligation of confidence, and the unauthorized use. One of the examples I mentioned already is the Google algorithm, and I'll mention a case involving Google in a few moments. But I just want to mention that lots of information has been found in case law to be protected by trade secrets, including ordinary business information, confidential technical information, even literary and artistic information in the context of pitches that have been made to TV studios. But I want to finish off trade secrets by talking about one of the major cases that's happened in the last few years. One of the main engineers, Anthony Lewandowski, left Google and went to Uber about 5 or 6 years ago. but he took with him a huge data set that Google had gathered while he was working at the company. And that was a breach of trade secrets. He was in violation of his former employment contract and the NDA that he had signed. Crucially, in the United States, theft of trade secrets is also a crime. And Lewandowski was sentenced to a large fine and also given a prison term. So it's worth pointing out that trade secret theft is a very strict offense. In relation to copyright law, one of the key things to remember is this application in the context of software. We know that companies can use copyright to prevent others from copying their software. You can't prevent someone from copying the function of the software, but you can prevent somebody from copying the code itself. In other words, if you create a new type of word processor, you can't prevent others from trying to create their own new versions of the software of the word processor, but they just can't use your software to copy. If they use your code, you can take an action against them. Famous examples of free and open source software include Linux, Mozilla, and Android. These are all examples of software that's protected by copyright, but which has been licensed down the chain of owners in order to allow others to improve the software as it goes along. It's a very clever process. Right now, the biggest case in AI and IP is a case that's taking place in the US and the UK, Getty Images against Stability AI. A lot of the AI processing and training that is happening right now, whether it be at OpenAI or Stability AI, is happening through the scraping of data and images from the web. At the moment, these companies are not paying the copyright owners for the use of those images or those texts. Getty Images is claiming that the use of their images by Stability AI is a violation of the copyright in those images. In the UK and the EU, the exceptions to allow data mining are actually quite limited in the commercial context. So it's quite possible that this will be a violation of copyright law in the EU and UK. However, in the United States, there's a defense to copyright infringement called fair use. And Stability AI may be able to make a plausible claim that their use of the images as training data to train their AI should actually be allowed as a fair use that doesn't conflict with the normal rights of the copyright owner. So we may see the EU and the US moving in different directions on AI. The EU has even proposed just this year a new AI Act. And in the Act, the EU is going to make a mandatory requirement of transparency on the part of AI companies. This will require companies to be open about what training data they are using. And so that will mean those companies will have to pay for the use of that data. If they do not comply with those rules, they may be fined up to 7% of their annual turnover, or 40 million euros. Another question that comes up from time to time, alongside the question of whether AI can be named on a patent application, is whether AI can be an author. We've seen with generative AI that you simply type into ChatGPT, write me a song in the style of Nick Cave, and it will do it. It will give you the lyrics to a song. And so, for such generative AI, the question becomes, who is really the author here? All of the creative choices are being made by the author, by the AI, rather than the human author. However, most jurisdictions to this point have said that AI creations cannot be protected by copyright and are thus in the public domain, or they are they're owned by the human author who's told the AI what to do. So the AI author debate goes on. You can read more about it at the link I've given you in my slide. But for all intents and purposes, right now AI cannot be named as an author. Trademark law, as I mentioned in the introduction, is relatively straightforward here. You apply for a trademark so that you have a distinctive brand for your company, a logo, a name. You can see from this slide the list of trademarks I've given you for all of these robotics companies are all distinctive. They stand out. That is the essential quality of a trademark. It must allow the consumer to distinguish the products of one company from another. So when you think about your company name and your logo, it will have to be different enough from your rivals in that field. And when you apply for the trademark, your rivals might complain if your company name is too close to theirs. And this is precisely what's happening in the Anthropic case. In the Anthropic AI case, they're suing Anthropic Inc. for trademark infringement. So we have two companies with a very similar name, operating in a very similar field, who are at war with each other over who has the right to that name. So it's a good indication that this issue of trademarks is likely to be more and more relevant in the AI field. Moving on to registered designs, our final IP right, we can see in this slide that the design of robots can be very important to their consumer and commercial appeal. A lot of robotics and robotic products are consumer-facing. And so the products should look attractive or enticing or friendly in some way. The kind of robot products that are designed to help children learn should look friendly and not scary. And so companies are investing more and more in the design of their products. You can register designs for robotic or AI-related products at the EU Intellectual Property Office. So obviously things like the Shark Ninja, this lawnmower, this pallet, the robotized pallet runner, all of these are registered designs. So recapping our main lecture, we've looked at all 5 of the IP rights: patents, trade secrets, copyright, trademarks, and registered designs. We've looked at case law and examples from each. And you now have a much clearer idea of the kind of IP portfolio that companies in the fields of robotic and AI tend to have. Most companies do not pursue only one type of IP. Smart companies take an approach where they look at all the different types and figure out where they fit in. Virtually all companies will need a trademark. That goes without saying. Your company name, your logo. If you're a pure software company, you may never apply for a patent. You may simply use copyright and trade secrets to protect your software. If you're dealing with hardware, in all likelihood, you will deal with patents as well as trade secrets. You may also deal with registered designs if you want to protect the look and feel of the product. So each company will have a different approach based on its own needs. So that's something for you to think about. After this lecture, you now have the tools to work out what types of IP are relevant to you and your business. So thank you for listening to me. I've given you my contact details on this last slide. Feel free to keep in touch and to contact me if you wish to get in touch in the future.